So we have a new Supreme Court decision, Unicolors versus H&M. This is a case about copyright registration and what happens if you make a mistake on your copyright registration. Justice Breyer delivered the opinion of the court February 24th, 2022. A valid copyright registration provides a copyright holder with important and sometimes necessary legal advantages. It is, for example, a prerequisite for bringing a civil action for infringement of a copyrighted work. You must register your copyright before you can bring an infringement action. Additionally, a plaintiff in an infringement action normally cannot obtain an award of statutory damages or attorney's fees for infringement that occurred prior to registration. To obtain registration, the author of a work must submit to the Register of Copyrights a copy of the work and an application. The application must provide information about the work. Some of this information is purely factual, some of it incorporates legal conclusions. If the Register of Copyrights determines that the work is copyrightable and meets other statutory requirements, she will issue a certificate of registration. The information on this certificate reflects the information that the copyright holder provided on the application. Naturally, the information provided on the application should be accurate. Nevertheless, the Copyright Act provides a safe harbor. It says that a certificate of registration is valid regardless of whether the certificate contains any inaccurate information, unless A, the inaccurate information was included on the application with knowledge that it was inaccurate, and B, the inaccuracy of the information, if known, would have caused the Register of Copyrights to refuse registration. The important point for our purposes is that a certificate of registration is valid even though it contains inaccurate information, as long as the copyright holder lacked knowledge that it was inaccurate. The question before us, the Supreme Court, concerns the scope of the phrase, with knowledge that it was inaccurate. The Court of Appeals for the Ninth Circuit believed that a copyright holder cannot benefit from the safe harbor and save its copyright registration from invalidation if its lack of knowledge stems from a failure to understand the law rather than a failure to understand the facts. So it's going to be a difference between a failure to understand the law rather than a failure to understand the facts. In our view, however, the law does not distinguish between a mistake of law and a mistake of fact. Lack of knowledge of either fact or law can excuse an inaccuracy in a copyright registration. We therefore vacate the Ninth Circuit Court of Appeals' contrary holding. The petitioner here, Unicolors, owns copyrights in various fabric designs. It sued the respondent, H&M, for copyright infringement. The jury found in Unicolors' favor, but H&M asked the trial court to grant it judgment as a matter of law. H&M argued, among other things, that Unicolors' registration certificate was invalid and that therefore Unicolors could not sue for infringement because it contained inaccurate information. Specifically, H&M argued that Unicolors' registration certificate was inaccurate because Unicolors had improperly filed a single application seeking registration for 31 separate works. H&M relied on a Copyright Office regulation which provides that a single registration can cover multiple works only if those works were included in the same unit of publication. H&M argued that the 31 fabric designs covered by Unicolors' single application and therefore single registration had not been published as a single unit of publication because Unicolors had initially made some of the designs available for sale exclusively to certain customers, while other designs were immediately available to the general public. Because the first statutory requirement for invalidating Unicolors' registration, a knowing inaccuracy, was satisfied, H&M argued, the district court should move to the second requirement and ask the Register of Copyrights whether it would have refused to register Unicolors' copyright if it had been aware of the inaccuracy. The district court denied H&M's motion for judgment as a matter of law. Among other things, it noted that a registration remains effective despite containing inaccurate information if the registrant included the inaccurate information in the registration application without knowledge that it was inaccurate. Because Unicolors did not know that it had failed to satisfy the single unit of publication requirement when it filed its application, the purported inaccuracy would not invalidate the registration. The Ninth Circuit disagreed. It agreed with H&M that Unicolors had failed to satisfy the single unit of publication requirement because it offered some of the 31 designs exclusively to certain customers. But did Unicolors know about this inaccuracy? In the Ninth Circuit's view, it did not matter whether Unicolors did or did not know that it had failed to satisfy the single unit of publication requirement. That was because, in the Ninth Circuit's view, the statute excused only good faith mistakes of fact, not law. And Unicolors had known the relevant facts, namely that some of the 31 designs had initially been reserved for certain customers. Unicolors sought certiorari or certification to the Supreme Court, asking us to review the Ninth Circuit's interpretation. We granted the petition. A brief analogy may help explain the issue we must decide. Suppose that John, seeing a flash of red in a tree, says, "There is a cardinal." But he is wrong. The bird is not a cardinal, it is a scarlet tanager. John's statement is inaccurate, but what kind of mistake has John made? John may have failed to see the bird's black wings. In that case, he has made a mistake about the brute facts. Or John may have seen the bird perfectly well, noting all of its relevant features, but not being much of a bird watcher, he may not have known that a tanager, unlike a cardinal, has black wings. In that case, John has made a labeling mistake. He saw the bird correctly, but he does not know how to label what he saw. Here, Unicolors' mistake is a mistake of labeling. But unlike John, who might consult an ornithologist about the birds, Unicolors must look to judges and lawyers as experts regarding the proper scope of the label single unit of publication. The labeling problem here is one of law. Does that difference matter? We think it does not. Our reasons are straightforward. For one thing, we follow the text of the statute. Section 411b1 says that Unicolors registration is valid regardless of whether the registration certificate contains any inaccurate information, unless the inaccurate information was included on the application for copyright registration with knowledge that it was inaccurate. Both case law and the dictionary tell us that knowledge has historically meant and still means the fact or condition of being aware of something. Unicolors says that when it submitted its registration application, it was not aware, as the Ninth Circuit would later hold, that the 31 designs it was registering together did not satisfy the single unit of publication requirement. If Unicolors was not aware of the legal requirement that rendered the information in its application inaccurate, it did not include that information in its application with knowledge that it was inaccurate. Nothing in the statutory language suggests that this straightforward conclusion should be any different simply because there was a mistake of law as opposed to a mistake of fact. To the contrary, nearby statutory provisions help confirm that here, knowledge refers to knowledge of the law as well as knowledge of the facts. Registration applications call for information that requires both legal and factual knowledge. See section 409.4, whether a work was made for hire, 409.8, when and where the work was published, 409.9, whether the work is a compilation or derivative work. Inaccurate information in a registration is therefore equally or more likely to arise from a mistake of law as a mistake of fact. That is especially true because applicants include novelists, poets, painters, designers, and others without legal training. Nothing in the statutory language suggests that Congress wanted to forgive those applicants' factual, but not their often esoteric legal mistakes. Other provisions of the Copyright Act confirm that, in this context, the word knowledge means actual, subjective awareness of both the facts and the law. Those provisions suggest that if Congress had intended to impose a scienter standard or knowledge standard other than actual knowledge, it would have said so explicitly. See section 121A, safe harbor for entities that did not know or have reasonable grounds to know that exported works would be used by ineligible persons. The DMCA, section 512C1A, the safe harbor for internet service providers who are not actually aware of infringing activities on their systems and are not aware of facts or circumstances from which infringing activity is apparent, which we call red flag knowledge, known, should have known, or willful blindness. See Section 901A8. Notice of protection requires actual knowledge or reasonable grounds to believe that a work is protected. See DMCA Section 1202B. Civil remedies for certain acts performed by a person who knows or has reasonable grounds to know that he or she was facilitating infringement. See 1401 C6 C2 for purposes of the paragraph regarding the unauthorized use of pre-1972 sound recordings. Knowing includes one who has actual knowledge, acts in deliberate ignorance of the truth or falsity of the information, or acts in a grossly negligent disregard of the truth or falsity of information. Again, gross negligence is same red flag knowledge, known should have known, willful blindness. The absence of similar language in the statutory provision before us tends to confirm our conclusion that Congress intended knowledge here to bear its ordinary meaning. For another thing, cases decided before Congress enacted Section 411B overwhelmingly held that inadvertent mistakes on registration certificates did not invalidate a copyright and thus did not bar infringement actions. Many of those cases involved mistakes of law, and then they cite to a bunch of cases you can see here. We can find no indication that Congress intended to alter this well-established rule when it enacted Section 411B. See Davis v. Michigan Department of Treasury from 1989. When Congress codifies a judicially defined concept, it is presumed, absent an express statement to the contrary, that Congress intended to adopt the interpretation placed on that concept by the courts. Also see Kurtzang v. John Wiley & Sons, the Dummies Book case from 2013. Further, those who consider legislative history will find that history persuasive here. It indicates that Congress enacted Section 411B to make it easier, not more difficult, for non-lawyers to obtain valid copyright registrations. The House report states that its purpose was to improve intellectual property enforcement in the United States and abroad. It did so in part by eliminating loopholes that might prevent enforcement of otherwise valid registered copyrights. The report specifically notes that some defendants in copyright infringement cases have argued that a mistake in the registration documents, such as checking the wrong box on the registration form, renders a registration invalid and thus forecloses the availability of statutory remedies. Congress intended to deny infringers the ability to exploit this potential loophole. Of course, an applicant for copyright registration, especially one who is not a lawyer, might check the wrong box on the registration documents as the result of a legal as well as factual error. Given this history, it would make no sense if 411B left copyright registrations exposed to invalidation based on applicants' good faith misunderstandings of the details of copyright law. H&M argues that our interpretation of the statute will make it too easy for copyright holders by claiming lack of knowledge to avoid the consequences of an inaccurate application. But courts need not automatically accept a copyright holder's claim that it was unaware of the relevant legal requirements of copyright law. We have recognized in civil cases that willful blindness may support a finding of actual knowledge. Circumstantial evidence, including the significance of the legal error, the complexity of the relevant rule, the applicant's experience with copyright law, and other such matters may also lead a court to find that an applicant was actually aware of or willfully blind to legally inaccurate information. H&M also argues that our interpretation is foreclosed by the legal maxim that ignorance of the law is no excuse. This maxim normally applies where a defendant has the requisite mental state in respect to the elements of a crime, but claims to be unaware of the existence of a statute proscribing or prohibiting his conduct. It does not apply in this civil case concerning the scope of a safe harbor that arises from ignorance of collateral legal requirements. Finally, H&M claims that neither Unicolors' petition for certiorari nor the Ninth Circuit's opinion addressed the question we decide here. The petition, however, asked us to decide whether a registration may be invalidated under Section 411B, even though there are no indicia or indicators of fraud as to the work at issue in the subject copyright registration. Fraud typically requires a knowing misrepresentation of a material fact. If, as the Ninth Circuit concluded, Section 411B1A does not require knowledge of legal errors, then it does not always require knowledge of the misrepresentation in the registration application, and therefore does not require the typical elements of fraud. Thus, the knowledge question that the parties have argued and which we decide was a subsidiary question fairly included in the petition's question presented. As to the decision below, the Ninth Circuit wrote that the knowledge inquiry is not whether Unicolors knew that including a mixture of confined and non-confined designs would run afoul of the single unit registration requirements. The inquiry is merely whether Unicolors knew that certain designs included in the registration were confined and therefore were each published separately to exclusive customers. In context, we understand this statement to hold that Unicolors' knowledge of the facts that produced the inaccuracy was sufficient to demonstrate its knowledge of the inaccuracy itself under the law. Unicolors' knowledge of the relevant law was irrelevant. The Ninth Circuit therefore explicitly addressed the question we here decide. For those reasons, the judgment of the Ninth Circuit is vacated and the case is remanded for further proceedings consistent with this opinion, which means that Unicolors will continue to win the case, and now I believe they're going to go on to a calculation of damages. It will probably be statutory damages. If that's what was at issue in the case, then Unicolors will be able to recover their statutory damages plus attorney's fees for H&M's alleged infringement. I am glad to see a sane copyright decision coming out of the Supreme Court. It's nice to know that I can continue to tell my clients, you can go and do your own copyright registrations. Attorneys don't really make any money much off of copyright registrations unless their client is really in the business of registering copyrights. When somebody asks an attorney, I just want to register this one thing in copyright, there's a rather high fee compared to what copyright registration involves, because the attorney needs to be able to pay their own bills. So if we're spending an hour or two registering a copyright for a client, when the client could do it for $65 on the copyright.gov website themselves, it really needs to mean something to the client to not have to do it themselves. Maybe the client is expecting some sort of infringement and therefore the registration is particularly valuable, but most copyright holders register their copyrights selectively, only when they think that they've got something that's going to be infringed, or only after they discover infringement, so that 90-day, 30-day rule really comes into play for those people. Since you can't get access to statutory damages, the $750 minimum damages, up to $150,000 per infringement, maximum damages for the worst kinds of willful copyright infringement, you can't get access to that unless you have timely registered your copyright. You also don't get access to attorney's fees, which often means you're suing over an amount of money that will be less than your attorney's fees. You might get a $10,000 award from the court after spending $40,000 in attorney's fees. So you've got a net negative $30,000 in that case. So it's very important that if you're going to litigate over your copyrights, that they be timely registered. Because of this decision, now attorneys can be more confident telling their clients, do your best to sincerely and accurately state your claims on a copyright registration, and you can rest assured that the registration will not automatically be invalidated because of some mistake that you made while sincerely trying to be accurate. Let me know what you think in the comments below. Not a explosive copyright decision, but rather something that makes sense, and how refreshing is it that something makes sense. Thanks for watching. Special thanks to my top supporters in February: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Gutbrodj, Torpedan, ShadowTycho, Earthbound Star, PureMagma, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everybody has a great week. I love you all.